If you don't have an estate plan, you really need to get one. I'm Orrin Ross. I'm an estate planning attorney, and I mainly work with people who are looking to make sure that when they pass away, their assets stay in their family and we don't have a prolonged court process where assets are frozen, people get into arguments, and it takes a really long time and costs a lot of money. One of the reasons we do that is for things like this. So this is an antique bed warmer that we got from my wife's parents, I think. It's not really anything, it's probably not worth much, but this is one of the types of things that can create a huge issue when we're going through a probate, especially if you don't have an estate plan laying out who gets what and where things go. If you have a family heirloom like this and people want to argue over it, it can easily take years and cost tens of thousands of dollars to go through that whole process. A lot of people will end up wasting much more than the item is worth to go through this process. They might spend $10,000, $15,000, $20,000 on attorney's fees for something that might be worth $100. But this happens a lot. I've talked to a lot of people who end up coming to me to set up a living trust for them because they've been through that probate process where everything was difficult, someone didn't agree, they got their own lawyer, everybody spent a ton of money, and they ended up getting less than they would have if everything had been straight down the line. So it's really important that you actually have an estate plan detailing where your assets go after you pass away. At a minimum, you need a will. But if you have a reasonable amount of assets, and especially if you live in the metro Atlanta area, where the probate process can take a very long time, it might be better for you to set up a living trust so that we can completely skip over that probate process. We also don't have to alert anyone who you're not leaving assets to. We have to let all the beneficiaries know, but we don't have to alert all your legal heirs, because even if you disinherit someone in a will, we still have to try to get them to sign off on the initial petition because they are a legal heir as far as the state of Georgia is concerned. So they have the ability to say, no, I don't think this is the proper will. They might not really have any evidence, but they can really slow things down and gum up the works. So if we have a living trust, we don't have to alert anyone if you don't want to leave assets to them. We can completely disinherit them. They're off to the side, and we don't have to alert them at all. So if you have a difficult family member who you're pretty sure that they're going to create issues when you pass away, it might be better to set up a living trust to completely skip over that probate process, and we can avoid a lot of the issues that come with a protracted court process. So if you want to learn a little bit more about estate planning or living trusts or wills, please call our office at 678-250-4281, or you can email me directly at orrin@orrinrosslaw.com.